chamber. We expect them, when they start, to go for several hours today. They've set aside 8 for the questioning of the senators questioning the House managers as well as the president's lawyers. We expect them to also take some breaks. So when they do, we will open up the phone lines and get your reaction. We also want to ask you today, what would you ask? What do you want your senator to ask of the House managers and the lawyers? We want to know what question you want them to ask. So we'll open up the phone lines and get your questions when they go to their first break. In the meantime, we'll continue to watch outside of the Senate chamber as well as inside.
Returned, Art.
Check. Oh, sorry about that. You are watching Vote Count 2020. I am Karthik Rajan. We have just tuned into the Senate chamber on C-SPAN as we follow the Senate impeachment trial of Donald J. Trump, the 45th president.
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Divine Shepherd, honor, glory, and power belong to you. Refresh our senators as they enter a new phase of this impeachment trial. May they realize that you have appointed them for this great service, and they are accountable to you. Lord, empower them to labor today with the dominant purpose of pleasing you, knowing that it is never wrong to do right. Give them resiliency in their toil as they remember your promise that they will reap a bountiful harvest if they don't give up. Help them to follow the road of humility that leads to honor as they find their safety in trusting you. We pray in your majestic name. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so here we are on day 10. Now today the senators will begin their questioning.
If there is no objection, the journal of proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment, while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The majority leader is recognized.
Today, the Senate will conduct up to 8 hours of questions to the parties delivered in writing to the Chief Justice. As a reminder, the two sides will alternate and an answer should be kept to 5 minutes or less. The majority side will lead off with a question from the senator from Maine.
Mr. Chief Justice,
The senator is recognized.
I send a question to the desk. On behalf of myself, Senator Murkowski, and Senator Romney.
This is a question for the counsel for the president. If President Trump had more than one motive for his alleged conduct, such as the pursuit of personal political advantage, rooting out corruption, and the promotion of national interests, how should the Senate consider more than one motive in its assessment of Article 1?
What?
Mr. Chief Justice, Senators, in response to that question, there are really two layers to my answer, because I'd like to point out first that even if there was only one motive, the theory of abuse of power that the House managers have presented, that subjective motive alone can become the basis for an impeachable offense, we believe is constitutionally defective. It is not a permissible way to frame a claim of an impeachable offense under the Constitution. So, but I'll put that to one side and address the question of mixed motive. If there were a motive that was a public interest, but also some personal interest, we think it follows even more clearly that that cannot possibly be the basis for an impeachable offense. And even the House managers, as they have framed their case, they have explained, and this is pointed out in our trial memorandum, that in the House Judiciary Committee report, they specify that the standard they have to meet is to show that this is a sham investigation. It's a bogus investigation. These investigations there's not any legitimate public purpose. That's the language, any legitimate public purpose. That's the standard they've set for themselves in being able to make this claim under their theory of what an abuse of power offense can be. So it's a very demanding standard that they've set for themselves to meet. And they've even said they came up and they talked a lot about the Bidens. They talked a lot about these issues in 2016 election interference, because they were saying there's not even a scintilla of any evidence of anything worth looking into there. And that's the standard that they would have to meet, showing that there's no possible public interest and the president couldn't have had any smidgen even of a public interest motive, because they recognize that once you get into a mixed motive situation, if there's both some personal motive, but also a legitimate public interest motive, it can't possibly be an offense. Because it would be absurd to have the Senate trying to consider, well, was it 48% legitimate interest and 52% personal interest, or was it the other way? Was it 53% and 46%? You can't divide it that way. And that's why they recognize that to have even a remotely coherent theory, the standard they have to set for themselves is establishing there is no possible public interest at all for these investigations. And if there is any possibility, if there is something that shows a possible public interest, and the president could have that possible public interest motive, that destroys their case. So once you're into mixed motive land, it's clear that their case fails. There can't possibly be an impeachable offense at all. And think about it, all elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions will affect the next election. There's always some personal interest in the electoral outcome of policy decisions. And there's nothing wrong with that. That's part of representative democracy. And to go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office. So the bottom line is, once you're into any mixed motive situation, once it is established that there is a legitimate public interest that could justify looking into something, just asking a question about something, the manager's case fails, And it fails under their own terms. They recognize that they have to show no possible public interest. There isn't any legitimate public interest. And they've totally failed to make that case. I think we've shown very clearly that both of the things that were mentioned, 2016 election interference and the Biden-Burisma situation, are things that raise at least some public interest. There's something worth looking at there. It's never been investigated in the Biden situation. Lots of their own witnesses from the State Department said that on its face, it appears to be a conflict of interest. It's at least worth raising a question about, asking a question about it. And there is that public interest, and that means their case absolutely fails. Thank you.
Thank you, counsel. The Democratic leader is recognized.
It should be Chuck Schumer, representative of New York. They're obviously trying to figure out who gets time now. Each of the responses is meant to be under 5 minutes.
Democratic leader asks the House managers. John R. Bolton's forthcoming book states that the president wanted to continue withholding $391 million in military aid to Ukraine until Ukraine announced investigations into his top political rival and the debunked conspiracy theory about the 2016 election. Is there any way for the Senate to render a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key eyewitnesses, or without seeing the relevant documentary evidence?
Thank you, Mr. Chief Justice. The short answer to that question is no. There's no way to have a fair trial without witnesses. And when you have a witness who is as plainly relevant as John Bolton, who goes to the heart of the most serious and egregious of the president's misconduct, who has volunteered to come and testify to turn him away, to look the other way, I think is deeply at odds with being an impartial juror. I would also add in response to the last question that if any part of the president's motivation was a corrupt motive, it was a causal factor in the action to freeze the aid or withhold the meeting, that is enough to convict. It would be enough to convict under criminal law. But here there's no question about the president's motivation. And if you have any question about the president's motivation, it makes it all the more essential to call the man who spoke directly with the president, that the president confided in and said he was holding up this aid because he wanted Ukraine to conduct these political investigations that would help him in the next election. If you have any question about whether it was a factor, the factor, a quarter of the factor, all of the factor, there is a witness, a subpoena away who can answer that question. But the overwhelming body of the evidence makes it very clear. On July 26th, the day after that phone call, Donald Trump speaks to Gordon Sondland. That's that conversation at Ukraine restaurant. And what does Gordon Sondland, what is the president's question of Gordon Sondland the day after that call? Is he going to do the investigations? Now, Counsel, the president would have you believe the president was concerned about burden sharing. Well, he may have had a generic concern about burden sharing in other contexts. But here, the motivation was abundantly clear. On that phone with Gordon Sondland, the only question he wanted an answer to was, is he going to do the investigation? Now, bear in mind, he's talking to the ambassador to the European Union. What better person to talk to if his real concern was about burden sharing than the guy responsible for Europe's burden sharing? But did the president raise this at all? Of course not. Of course not. And if you have any question about it at all, you need to hear from his former national security advisor. Don't wait for the book. Don't wait till March 17th when it is in black and white to find out the answer to your question. Was it all the motive, some of the motive, or none of the motive? Now, we think, as I mentioned, the case is overwhelmingly clear without John Bolton, but if you have any question about it, you can erase all doubt. Now, let me show you a video, underscore number 2, slide 2, how important this is.
This House managers, really, their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
Last video, which is even more important and on point for Mr. Bolton. Number 3.
And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the president ever linked the presidential meeting to any investigations. Anyone who spoke with the president said that the president made clear that there was no linkage between security assistance and investigations.
No, that's not correct, right? Because, of course, Mick Mulvaney said that the money was linked to these investigations. He said, in acknowledging a quid pro quo, they do it all the time and we should just get over it. Gordon Sondland also said, the president said, on the one hand, no quid pro quo, but also made it clear that Zelensky had to go to the mic and announce these investigations.
Thank you.
Thank you, Justice.
Mr. Chief Justice,
Senator Thune.
I have a question for the President's counsel.
To the President's counsel, would you please respond to the arguments or assertions the House managers just made in response to the previous question?
Mr. Chief Justice, Senators, a couple of points that I'd like to make. Manager Schiff suggested that there was no evidence the president was actually interested in burden sharing because he didn't apparently, according to David Hale, raise it in the telephone conversation that he had with Gordon Sondland that Hale claims to have overheard at a restaurant in Kiev. But let's look at the real evidence. As we explained, on June 24th, there is an email in the record showing, it's an email from one person at the Department of Defense to another with a subject line of POTUS follow-up, President of the United States follow-up, asking specifically about burden sharing. It says, quote, what do other NATO members spend to support Ukraine, end quote. That was what they were following up on for the president. And in the transcript itself, excuse me, in the transcript of the July 25th call itself, the president asked, he said, we spend a lot of effort and a lot of time for Ukraine, much more than the European countries are doing, and they should be helping you more than we are. Germany does almost nothing for you. All they do is talk, and I think it's something you should really ask them about. And he goes on to say that he talks to Angela Merkel about it, and that they're not really doing as much as the United States is doing. He's raising burden sharing, and President Zelensky agreed with him. Now, Manager Schiff also suggested that there is evidence of some connection between the military assistance and investigations into 2016 election interference because of a statement that Acting Chief of Staff Mulvaney made at a press conference But it's been clear in the record since that press conference that what he was saying was garbled and or misunderstood, and he immediately clarified and said on that day, quote, "The president never told me to withhold any money until the Ukrainians did anything related to the server," end quote. And similarly, he issued a statement just the other day, making clear again that he said, this is from his counsel, so it's phrased in the third person, nor did Mr. Mulvaney ever have a conversation with the president or anyone else indicating that Ukrainian military aid was withheld in exchange for Ukrainian investigation of Burisma, the Bidens, or the 2016 election. That is Mr. Mulvaney's statement. Lastly, onto the point of whether this chamber should hear from Ambassador Bolton. And I think it's important to consider what that means, because it's not just a question of, well, should we just hear one witness? That's not what the real question is going to be. For this institution, the real question is, what is the precedent that is going to be set for what is an acceptable way for the House of Representatives to bring an impeachment of a president of the United States to this chamber? And can it be done in a hurried, half-baked, partisan fashion they didn't even subpoena John Bolton below. They didn't even try to get his testimony. And to insist now that this body will become the investigative body, that this body will have to do all the discovery, and that this institution will be effectively paralyzed for months on end because it has to sit as a court of impeachment, while now discovery is done because it would be Ambassador Bolton. And if there are going to be witnesses, then the president would have to, in order, they said fair trial, fair adjudication, then the president would have to have his opportunity to call his witnesses. And there'd be depositions, and this would drag on for months. And then that's the new precedent. Then that's the way all impeachments operate in the future. The House doesn't have to do the work. They do it quick, they throw it over the transom, and this institution gets derailed and has to deal with it. And that should not be the way, that should not be the precedent that is set here for the way this body will have to handle all impeachments in the future. Because if it becomes that easy for the House to do it, they'll be doing it a lot. Thank you.
The senator from Massachusetts.
Send a question to the desk.
So each of the senators sends the question to the Chief Justice. The Chief Justice reads the questions, and whichever council it's going to, they send up a person to respond to the question.
Question from Senator Markey to the House managers. On Monday, President Trump tweeted, "The Democrat-controlled House never even asked John Bolton to testify." End quote. So that the record is accurate, did House impeachment investigators ask Mr. Bolton to testify?
Senators, the answer is yes. Of course, we asked John Bolton to testify in the House, and he refused. We asked his deputy, Dr. Kupperman, to testify, and he refused. Fortunately, we asked their deputy, Dr. Fiona Hill, to testify, and she did. We asked her deputy, Colonel Vindman, to testify, and he did. But we did seek the testimony of John Bolton, as well as Dr. Kupperman, and they refused. When we subpoenaed Dr. Kupperman, he sued us, took us to court. When we raised a subpoena with John Bolton's counsel, the same counsel for Dr. Kupperman, the answer was, Senator, you serve us with a subpoena and we will sue you too. We knew, based on the McGahn litigation, it would take months, if not years, to force John Bolton to come and testify. And I should point out, because I think this is an essential point to underscore, as the president's lawyers say, they didn't try hard enough to get John Bolton, or they should have subpoenaed John Bolton. That's what they're telling you. But let me show you what they're telling the court in the McGahn litigation. If we could pull up slide number 39. This is the president's lawyers in court in the McGahn litigation. In the Court of Appeals right now, quote, "The committee," meaning our committee, lacks Article 3 standing to sue to enforce a congressional subpoena demanding testimony from an individual on matters related to duties as an executive branch official. I mean, it takes your breath away, the duplicity of that argument. They're before you saying they should have tried harder to get these witnesses, they should subpoena, they should have litigated for years, and down the street in the federal courthouse, they're arguing, Judge, you need to throw them out. They have no standing to sue to force a witness to testify. Are we really prepared to accept that? Now, counsel says, think about the precedent that we would be setting if you allow a House to impeach a president and you permit them to call witnesses. Well, I would submit, think about the precedent you will be setting if you don't allow witnesses in a trial. That to me is the much more dangerous precedent here. But I'll tell you there's something even more dangerous, and this was something that we anticipated from the very beginning, which is we understood when we got to this point, they could no longer contest the facts that the president withheld military aid from an ally at war to coerce that ally to doing the president's political dirty work. So now they have fallen back on, you shouldn't hear any further evidence, any further witnesses on this subject. What's more, we're going to use the end-all argument, so what? A president is free to abuse their power. We're going to rely on a constitutional theory, a fringe theory, that even the advocate of which says is outside of the consensus of constitutional law, to say that a president can abuse his power with impunity. Now imagine where that leads. A president can abuse his power with impunity. Now, that argument made by Professor Dershowitz is at odds with the Attorney General's own expressed opinion on the subject, with Ken Starr's expressed opinion on the subject, with not only other counsel for the president, Jonathan Turley, who testified in the House, says that theory is constitutional, effectively nonsense. But even 60-year-old Alan Dershowitz doesn't agree with 81-year-old Alan Dershowitz. And for a reason, because where that conclusion leads us is that a president can abuse his power in any kind of way, and there's nothing you can do about it. Now, are we really ready to accept the position that this president or the next can withhold hundreds of millions of dollars of military aid to an ally at war unless they get help in their reelection? Would we say that you could, as president, withhold disaster relief from a governor unless that governor got his attorney general to investigate the president's political rival? That, to me, is the most dangerous argument of all. It's a danger to have a president who engage in this conduct. It's a danger to have a trial with no witnesses and set that precedent. But the biggest danger of all, I think, would be to accept the idea that a president can abuse his office in this way and the Congress is powerless to do anything about it. That is certainly not what the founders intended.
Mr. Chief Justice.
The senator from Tennessee.
Thank you, Mr. Chief Justice. I send a question to the desk on my behalf and also joined by Senators Loeffler, Lee, Kramer, and McSally.
The senators ask of counsel for the president, is the standard for impeachment in the House a lower threshold to meet than the standard for conviction in the Senate? And have the House managers met their evidentiary burden to support a vote of removal?
What kind of bullshit question is that? Oh my
Mr.
God.
Chief
It's like
Justice,
high school
senators,
softball.
the standard in the House, of course, the House is not making a final determination. In the structure of the Constitution, an impeachment is simply an accusation. And as in most systems where there is simply an accusation being made, the House does not have to adhere to the same standard that is used in the Senate. In most instances, House members have suggested in debates on articles of whether or not to approve articles of impeachment that they should have clear and convincing evidence in the view of the members voting on it that there was some impeachable offense, and that is all. Some not even that standard. And so it is simply enough evidence that an accusation can be made. It is definitely a lower standard than the standard that has to be met here on a trial for an ultimate verdict. The Constitution speaks in terms of a conviction in the Senate. And as both Professor Dershowitz and Judge Starr pointed out in their comments, everywhere in the Constitution that there's any mention of impeachment, it is spoken of in terms of the criminal law. The offenses that define the jurisdiction for the Senate sitting as a court of impeachment are treason, bribery, and high crimes and misdemeanors. The Constitution speaks of a conviction upon being convicted in the Senate. It speaks of all crimes being tried by jury except in cases of impeachment, again suggesting notions of the criminal law. And as we pointed out in our trial memorandum, all of these textual references make it clear that the standards of the criminal law should apply in the trial, certainly to the extent of the burden and standard of proof.
Right, so you have to have witnesses. There's no such thing as a trial without a witness.
Beyond a reasonable doubt.
Unbelievable.
And it's very clear that there is not any requirement for proof beyond a reasonable doubt simply for the House to vote upon articles of impeachment. There's a very much higher standard at stake here. As we pointed out in our trial memorandum, the mere accusation made by the House comes here with no presumption of regularity in its favor. The Senate sits as trier of both fact and law, reviewing both factual and legal issues de novo. And the House managers are held to a standard of proving proof beyond a reasonable doubt of every element of what would be a cognizable, impeachable offense. Here, they have failed in their burden of proof. They have also failed on the law. They have not stated in the articles of impeachment anything that on its face amounts to an impeachable offense. And on the fact, I think we have demonstrated very clearly that they have not presented facts that would amount to an impeachable offense, even under their own theories. They have presented only part of the facts and left out the key facts. And Mr. Papura, I think, went through very effectively showing that there are some facts that don't change. The transcript of the July 25th call shows the president doing nothing wrong. President Zelensky said he never felt any pressure. His other advisors have said the Ukrainians never felt any pressure. They didn't think there was any quid pro quo. They didn't even know that the military assistance had been held up until the Politico article at the end of August. The only two people with statements on record who spoke to the president, who are Sondland and Senator Ron Johnson, report that the president said to them there was no quid pro quo, and the aid flowed without anything ever being done related to investigations. That is what's in the record. That is what the House managers have to rely on to make their case, and they have failed to prove their case beyond a reasonable doubt, failed even to prove it by clear and convincing evidence, failed to prove it at all, in my opinion. Thank you.
Thank you, counsel.
So partisan.
The senator from California is recognized.
Thank you. Mr. Chief Justice, I send a question to the House managers.
Senator Feinstein asks the House managers. The President's counsel stated that, quote, there is simply no evidence anywhere that President Trump ever linked security assistance to any investigations, end quote. Is that true?
Is it Schiff again?
Thank you, Mr. Chief Justice, and thank you, Senator, for that question.
No, good. It's someone else.
The President's counsel is not correct. There is, in fact, overwhelming evidence that the President withheld the military
Senator
aid
Crow,
directly to get
Representative
a
Crow.
personal political benefit to help his individual political campaign. There's a few points that I'd like to submit for your consideration. First, look no further than the words of the President's acting Chief of Staff, Mick Mulvaney, who on October 17th,
Jason Crow,
2019,
Democrat, Colorado.
during a national press conference, mentioned, quote, or he was asked about the direct connection between the aid, and he said, quote, did he, meaning President Trump, referring to he, quote, also mentioned to me in passing the corruption related to the DNC server? Absolutely, no question about it, but that's it. And that's why we held up the money, end quote. He was repeating the President's own explanation relayed directly to him. Second, Gordon Sondland testified he spoke by phone with President Trump on September 7th. The President denied there was a quote quid pro quo, but then outlined the very quid pro quo that he wanted from Ukraine. Then he told President Sondland to quote, that President Zelensky should quote, go to the microphone and announce the investigations. He should want to do it. Third, the President's own advisors, including the Vice President and Secretary Pompeo, were also aware of the direct connection. In Warsaw on September 1st, Ambassador Sondland told Vice President Pence that he was concerned the delay in security assistance had become, quote, tied to the issue of investigations. The Vice President simply nodded, tacitly acknowledging the conditionality of the aid. Fourth, we heard from Ambassador Taylor, who in direct emails and texts said it was crazy to tie the security assistance to the investigations. Five, we also know there's no other reason. The entire apparatus and structure of the Defense Department, the State Department, that should have been dealing with the other legitimate reasons, the policy debate that the President's counsel wants you to believe that this was about, they were all kept in the dark. And the supposed interagency process that they made up several months after the fact had ended months before during the last interagency meetings. And I'll make one final point. Again, if you have any lingering questions about direct evidence, any thoughts about anything we just talked about, anything I just relayed, or that we've talked about the last week, there is a way to shed additional light on it. You can subpoena Ambassador Bolton and ask him that question directly.
Thank you, Mr. Manager.
Mr. Chief Justice,
Senator from Utah.
I send a question to the desk.
Senator Lee asks of Counsel for the President. The House managers have argued aggressively that the President's actions contravened U.S. foreign policy. Isn't it the President's place, certainly more than the place of career civil servants, to conduct foreign policy?
No, it is not. It is absolutely not. That's idiotic. We have a huge foreign policy apparatus for a reason. So presidents can come and go.
Thank you, Mr. Chief Justice.
Moron.
Senators, and thank you for that question. It is definitely the
Not.
President's place.
You're wrong.
To set
You're totally
US foreign
wrong.
policy, and the Constitution makes this clear.
No, it doesn't.
Article 2, Section 1 vests the entirety of the executive authority in a President of the United States. And it's critically important in our constitutional structure that that authority is vested solely in the President, because the President is elected by the people every 4 years. That's what gives the President democratic legitimacy to have the powers that he is given under the Constitution. Our system is somewhat unique in the very broad powers that are assigned to the executive, but it works and it makes sense in a democratic system precisely because he is directly accountable to the people for the policies that he sets. Those who are staffers in the executive branch bureaucracy are not elected by the people. They have no accountability, and they have no legitimacy or authority that comes from an election by the people. And so it's critically important to recognize the president sets foreign policy. Of course, within some constraints, there's roles for Congress in foreign affairs to some extent. Statutes can be passed, funding provisions can be passed that relate to it. But the Supreme Court has recognized time and again that the president is, as the court said in Curtis Wright, the sole organ of the nation in foreign affairs. So he sets foreign policy. And if staffers disagree with him, that does not mean that the president is doing something wrong. And this is a critical point, because this is one of the centerpieces of the abuse of power theory that the House managers would like this body to adopt. And that is that they are going to impeach the president based solely on his subjective motive. The premise of their case is the objective actions that were taken were perfectly permissible and within the president's constitutional authority. But if his real reason, if we get inside his head and figure it out, then we can impeach him. And the way that they have tried to explain that they can prove that the president had a bad motive is they say, well, we compare what did the president want to do with what the interagency consensus was. And I mentioned this the other day. They say that the president defied and confounded every agency in the executive branch. That's a constitutionally incoherent statement. The president cannot defy the agencies within the executive branch that are subordinate to him. It is only they who can defy the president's determinations of policy. And what this all boils down to really is it shows that this case is built on a policy difference, and a policy difference where the president is the one who gets to determine policy because he's been elected by the people to do that. And we're right now only a few months away from another election where the people can decide for themselves whether they like what the president has done with that authority or not. And that's the way
Except you've got the elections
disputes
fixed.
about policy like that should be resolved.
That's
It's
the
not
problem.
legitimate to say that there's some interagency consensus that disagrees with the president, and therefore we can show he did something wrong, and therefore he could be impeached. That's an extraordinarily dangerous proposition because it lacks any democratic legitimacy whatsoever.
Too much
It's
credit to the
contrary
president.
to the Constitution, and it should be rejected by this body. The president is the one who gets to set foreign policy because that's the role assigned to him in the Constitution. And it was even Lieutenant Colonel Vindman, who had complained about the July 25th call, himself ultimately agreed that it was only a policy difference. It was a policy concern that he raised about the call. That's not enough to impeach a president of the United States. Thank you.
Thank you, Counsel. The senator from New Hampshire.
Mr. Chief Justice, I send a question to the desk.
Again, we're watching the impeachment trial in the Senate. Senators are asking questions. The Chief Justice
Senator Shaheen asks the House managers.
reading them aloud.
The President's counsel has argued that the alleged conduct set out in the articles does not violate a criminal statute and thus may not constitute grounds for impeachment as high crimes and misdemeanors. Does this reasoning imply that if the President does not violate a criminal statute, he could not be impeached for abuses of power, such as ordering tax audits of political opponents, suspending habeas corpus rights, indiscriminately investigating political opponents, or asking foreign powers to investigate members of Congress?
Mr. Chief Justice, Senators, I appreciate the question. The simple answer is that a president can be impeached without a statutory crime being committed.
This is Sylvia Garcia.
That was the position,
Democrat,
and the
Texas.
question was rejected in President Nixon's case and rejected again in President Clinton's case. it should be rejected here in President Trump's case. The great preponderance of legal authority confirms that impeachable offenses of legal authority confirms that it is not defined in criminal conduct. This authority includes nearly every legal scholar to have studied the issue, multiple Supreme Court justices who addressed it in public remarks, and prior impeachments in the House. This conclusion follows that constitutional history, text, and structure, and reflects the absurdities and practical difficulties that would result were the impeachment power confined to indictable crimes. As slide 35 shows, first, the plain text of the Constitution does not require that an offense be a crime in order for it to be impeachable. Alexander Hamilton explained that impeachable offenses, high crimes, and misdemeanors are defined fundamentally by the abuse or violation of some public trust. Some public trust. They are political as they relate chiefly to injuries done immediately to the society itself. Offenses against the Constitution are different than offenses against the criminal code. Some crimes, like jaywalking, are not impeachable, and some forms of misconduct often offend the Constitution and the criminal law. Impeachment and criminality must therefore be assessed separately, even though the President's commission of indictable crimes may further support a case of impeachment and removal. The American experience with impeachment confirms this. A strong majority of impeachments voted by the House since 1789 have included one or more allegations that did not charge a violation of criminal law. Although President Nixon resigned before the House could consider the articles of impeachment against him, the Judiciary Committee's allegations encompassed many, many non-criminal acts. And in President Clinton's case, the Judiciary Committee report accompanying the articles of impeachment to the House floor stated that, quote, the actions of President Clinton do not have to rise to the level of violating the federal statute regarding articles obstruction of justice in order to justify impeachment. The framers intended impeachment to reach the full spectrum of presidential misconduct that threatened the Constitution. They also intended that our Constitution endure throughout the ages. In other words, if they named 1, 2, and 3, but new ones came up, you had to keep up with the times, so it was better to have the full spectrum of presidential misconduct. Because they could not anticipate and specifically prohibit every single threat a president might someday pose, the framers adopted a standard sufficiently general and flexible to meet unknown future circumstances. This standard was meant, as Mason put it, to capture all manner of great and dangerous offenses and compatible with the Constitution. When the president uses the powers of his high office to benefit himself while injuring or ignoring the American people he is duty bound to serve, he has committed an impeachable offense. The records of the Constitutional Convention offer further clarity. At the Constitutional Convention itself, no delegate linked impeachment to the technicalities of criminal law. Instead, the framers principally intended impeachment for 3 forms of presidential wrongdoing, the ABCs of impeachment. A, abuse of power. B, betrayal of the national interest through foreign entanglements. And C, corruption of office and elections. When a president abuses his power to obtain illicit help in his election from a foreign power and undermine our national security and election integrity, it is a trifecta.
Thank you. Thank you, Counsel.
Thank you.
Senator from Louisiana.
Mr. Chief Justice, along with Senator Blackburn and Senator Cornyn, I send a question to the desk. for the House managers and for counsel for the president.
In the case of such a question addressed to both sides, they will split the 5 minutes equally. The senators asked, why did the House of Representatives not challenge President Trump's claims of executive privilege and/or immunity during the House impeachment proceedings? We'll begin with the House managers. We'll have to start the clock soon.
Mr. Chief Justice, distinguished senators, thank you for your question. The answer is simple. We did not challenge any claims related to executive privilege because, as the president's own counsel admitted during this trial, the president never raised the question of executive privilege. What the president did raise was this notion of blanket defiance, this notion that the executive branch, directed by the president, could completely defy any and all subpoenas issued by the House of Representatives, not turn over documents, not turn over witnesses, not produce a single shred of information in order to allow us to present the truth to the American people. In the October 8th letter that was sent to the House of Representatives, there was no jurisprudence that was cited to justify the notion of blanket defiance. There has been no case law cited to justify the doctrine of absolute immunity. In fact, every single court that has considered any presidential claim of absolute immunity, such as the one asserted by the White House, has rejected it out of hand.
Counsel for the President.
Mr. Chief Justice, Senators, thank you for that question. Let me frame this partly in response to what Manager Jeffries said, and I went through this before. The idea that there was blanket defiance and no explanation and no case law from the White House is simply incorrect. I put up slides showing the letters, a letter from October 18th that explained specifically that the subpoenas that had been issued by the House because they were not authorized by a vote from the House were invalid. And there was a letter from the White House counsel saying that. There was a letter from OMB saying that. There was a letter from the State Department saying that. There were specific rationales given, citing the cases, Watkins, Roomley, and others, explaining that defect. The House managers, Manager Schiff, chose not to take any steps to correct that. We also pointed out other defects. We asserted the doctrine of absolute immunity for senior advisors to the president, which has been asserted by every president since the 1970s. They chose not to challenge that in court. We also explained the problem that they didn't allow agency counsel to be present at depositions. They chose not to challenge that in court. These were specific legal reasons, not blanket defiance, right? That's just a misrepresentation of the record. And there was no attempt to have that adjudicated in court. And the reason that there was no attempt is that the House Democrats were just in a hurry. They had a timetable. One of the House managers said on the floor here, they had no time for courts. They had to impeach the president before the election. So they had to have that done by Christmas. That's why the proper process wasn't followed here, because it was a partisan and political impeachment that they wanted to get done all around for the election. Thank you.
Thank you, Counsel. Senator from Vermont. Senator Leahy asks the House managers. The President's counsel argues that there was no harm done, that the aid was ultimately released to Ukraine. The President met with Zelensky at the UN in September, and that this President has treated Ukraine more favorably than his predecessors. What is your response?
Mr. Chief Justice and Senator, thank you so much for your question. Contrary to what the White House counsel has said or has claimed, that there was no harm, no foul, that the aid eventually got there.
Val Demings of Florida.
We promised Ukraine in 2014 that if they gave up their nuclear arsenal, that we would be there for them, that we would defend them, that we would fight along beside them. 15,000 Ukrainians have died. It was interesting the other day when the White House counsel said that no American life was lost, and we are always grateful and thankful for that. But what about our friends? What about our allies in Ukraine? According to Diplomat Holmes and Ambassador Taylor, that our Ukrainian friends continue to die on the front lines, those who were fighting for us, fighting Russian aggression. When you fight Russian aggression, when the Ukrainians have the ability to defend themselves, they have the ability to defend us. The aid, although it did arrive, it took the work of some senators in this room who had to pass additional laws to make sure that the Ukrainians did not lose out on $35 million additional dollars. And contrary to the president's tweet that all of the aid arrived and that it arrived ahead of schedule, that is not true. All of the aid has not arrived. And let's talk about what kind of signal withholding the aid for no legitimate reason. The president talked about burden sharing, but nothing had changed on the ground. Holding the aid for no legitimate reason sent a strong message that we would not want to send to Russia, that the relationship between the United States and Ukraine was on shaky ground. It actually undercut Ukraine's ability to negotiate with Russia, with whom, as everybody in this room knows, is in an active war, in a hot war. So when we talk about the aid eventually got there, no harm, no foul, that is not true, senators, and I know that you know that. There was harm and there was foul. And let us not forget that Ukraine is not an enemy. They're not an adversary. They are our friends.
Senator Cruz.
Mr. Chief Justice, I send a question to the desk.
Boy, this is going to be good. Ted Cruz's question is coming next. We are watching the Senate impeachment trial of Donald J. Trump, the 45th president of the United States.
The question is addressed to counsel for the president. As a matter of law, does it matter if there was a quid pro quo? Is it true that quid pro quos are often used in foreign policy?
Man, they set him up with these softballs.
Thank you very much for your question. Yesterday, I had the privilege of attending the rolling out of a peace plan by the President of the United States regarding the Israel-Palestine conflict. And I offered you a hypothetical the other day. What if a Democratic president were to be elected and Congress were to authorize much money to either Israel or the Palestinians, and the Democratic president were to say to Israel, no, I'm going to withhold this money unless you stop all settlement growth, or to the Palestinians, I will withhold the money Congress authorized to you unless you stop paying terrorists. And the president said, quid pro quo. If you don't do it, you don't get the money. If you do it, you get the money. There's no one in this chamber that would regard that as in any way unlawful.
It is unlawful. You're out of your mind. The president can't do that.
Unlawful is
it's
if
congressional funds, dude.
Were in some way illegal. Now, we talked about motive. There are three possible motives that a political figure can have. One, a motive in the public interest, and the Israel argument would be in the public interest. The second is in his own political interest. And the third, which hasn't been mentioned, would be in his own financial interest, his own pure financial interest, just putting money in the bank. I want to focus on the second one for just one moment. Every public official that I know believes that his election is in the public interest. And mostly you're right. Your election is in the public interest. And if a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment. I quoted President Lincoln. When President Lincoln told General Sherman to let the troops go to Indiana so that they can vote for the Republican Party. Let's assume the president was running at that point. And it was in his electoral interest to have these soldiers put at risk the lives of many, many other soldiers who would be left without their company. Would that be an unlawful quid pro quo? No, because the president, A, believed it was in the national interest, but B, he believed that his own election was essential to victory in the Civil War. Every president believes that. That's why it's so dangerous to try to psychoanalyze a president, to try to get into the intricacies of the human mind. Everybody has mixed motives. And for there to be a constitutional impeachment based on mixed motives would permit almost any president to be impeached. How many presidents have made foreign policy decisions after checking with their political advisors and their pollsters? If you're just acting in the national interest, what do you need pollsters? What do you need political advisors? Just do what's best for the country. But if you want to balance what's in the public interest with what's in your party's electoral interest and your own electoral interest, it's impossible to discern how much weight is given to one to the other. Now, we may argue that it's not in the national interest for a particular president to get reelected or for a particular senator or member of Congress. And maybe we're right. It's not in the national interest for everybody who's running to be elected. But for it to be impeachable, you would have to discern that he or she made a decision solely on the basis of, as the House managers put it, corrupt motives. And it cannot be a corrupt motive if you have a mixed motive that partially involves the national interest, partially involves electoral, and does not involve personal pecuniary interests. And the House managers do not allege that this decision, this quid pro quo, as they call it, and the question is based on the hypothesis there was a quid pro quo, I'm not acting the facts, they never allege that it was based on pure financial reasons. It would be a much harder case if a hypothetical president of the United States said to a hypothetical leader of a foreign country, unless you build a hotel with my name on it, and unless you give me $1 million kickback, I will withhold the funds. That's an easy case. That's purely corrupt and in the purely private interest. But a complex middle case is, I want to be elected. I think I'm a great president. I think I'm the greatest president there ever was. And if I'm not elected, the national interest will suffer greatly. That cannot be an impeachable offense. Thank you, Mr. Chief Justice.
Wow.
Recognize the Democratic leader.
Mr. Chief Justice, I send a question to the desk.
He sounds like Trump. His attorney is just mimicking him, saying, I am the greatest.
The question is for the House managers. Would you please respond to the answer that was just given by the President's counsel?
I would be delighted. There are
That's
two arguments that Professor Dershowitz makes. One that is, I have to say, a very odd argument for a criminal defense lawyer to make, and that is, it is highly unusual to have a discussion in trial about the defendant's state of mind, intent, or mens rea. In every courtroom in America, in every criminal case, or almost every criminal case, except for a very small sliver that are strict liability, the question of the defendant's intent and state of mind is always an issue. So this is nothing novel here. You don't require a mind reader. In every criminal case, and I would assume in every impeachment case, yes, you have to show that the president was operating from a corrupt motive, and we have. But he also makes an argument that all quid pro quos are the same and all are perfectly copacetic. Now, some of you said earlier, well, if they could prove a quid pro quo over the military, now that would be something. Well, we have. So now the argument shifts to all quid pro quos are just fine, they're all the same. Well, I'm going to apply Professor Dershowitz's own test. He talked about the step test. John Rawls, the philosopher. Let's put the shoe on the other foot and see how that changes our perception of things. But I want to merge that argument with one of the other presidential counsel's argument when they resorted to the whataboutism about Barack Obama's open mic. Now, that was a very poor analogy, I think you'll agree, but let's use that analogy and let's make it more comparable to today and see how you feel about this scenario. President Obama on an open mic says to Medvedev, hey, Medvedev, I know you don't want me to send this military money to Ukraine because they're fighting and killing your people. I want you to do me a favor, though. I want you to do an investigation of Mitt Romney. And I want you to announce you found dirt on Mitt Romney. And if you're willing to do that, quid pro quo, I won't give Ukraine the money they need to fight you on the front line. Do any of us have any question that Barack Obama would be impeached for that kind of misconduct? Are we really ready to say that that would be okay if Barack Obama asked Medvedev to investigate his opponent and would withhold money from an ally that it needed to defend itself to get an investigation of Mitt Romney? That's the parallel here. And to say, well, yes, we condition aid all the time for legitimate reasons, yes. For legitimate reasons, you might say to a governor of a state, hey, governor of a state, you should chip in more towards your own disaster relief. But if the president's real motive in depriving a state of disaster relief is because that governor won't get his attorney general to investigate the president's political rival, are we ready to say that the president can sacrifice the interests of the people of that state, or in the case of Medvedev, the people of our country, because all quid pro quos are fine, it's carte blanche? Is that really what we're prepared to say with respect to this president's conduct or the next? Because if we are, then the next president of the United States can ask for an investigation of you. They can ask for help in their next election from any foreign power. And the argument will be made, nope, Donald Trump was acquitted for doing exactly the same thing. Therefore, it must not be impeachable. Now, bear in mind that efforts to cheat an election are always going to be in proximity to an election. And if you say you can't hold a president accountable in an election year where they're trying to cheat in that election, then you are giving them carte blanche. So all quid pros are not the same. Some are legitimate and some are corrupt, and you don't need to be a mind reader to figure out which is which. For one thing, you can ask John Bolton.
Thank you, Mr. Manager.
Mr. Chief Justice,
Senator from Iowa.
I send a question to the desk.
I bet it's going to be a dickhead question.
Senator Grassley asks counsel for the president. Does the House's failure to enforce its subpoenas render its, quote, obstruction of Congress, end quote, theory unprecedented?
They threatened to sue them if they issued a subpoena. And they outright rejected all the other subpoenas.
Mr. Chief Justice, Senators, the answer is yes. As far as I am aware, there has never been a prior instance in which there's been an attempt, even in the House, as in the Nixon proceeding, never mind in the Clinton proceeding, which actually left the House and came to the Senate, to suggest that there can be obstruction of Congress when there hasn't been anything beyond simply issuing a subpoena, getting resistance, and then throwing up your hands and giving up and saying, oh, well, that's obstruction. In the Clinton situation, most of the litigation was with the independent counsel, and there were privileges asserted and litigation again and again. But the point is that the issues about the privileges were all litigated and they were resolved before things came to this body. Similarly, in the Nixon impeachment proceeding within the House, a lot of investigation had been done by the special counsel, and there was litigation over assertions of privileges there in order to get at the tapes, and some tapes or transcripts had already been turned over. But again, there was litigation about the assertion of the privilege in response to the grand jury subpoena that then fed into the House's proceedings. So it would be completely unprecedented for the House to attempt to actually bring a charge of obstruction into the Senate, where all they can present is, well, we issued a subpoena and there were legal grounds asserted for the invalidity of the subpoena. And there were different grounds, as I've gone through. I won't repeat them all in detail here, but some were because the subpoenas were just invalid when issued because there was no vote. Some is that the subpoenas for witnesses were invalid because senior advisors to the president had absolute immunity for compulsion. Some were that they were forcing executive branch officials to testify without the benefit of agency counsel and executive branch counsel with them. So the various reasons asserted for the invalidity and the defects in various subpoenas, and then no attempt to enforce them, no attempt to litigate out what the validity or invalidity might be, but just bring it here as an obstruction charge is unprecedented. And I'll note the House managers have said, and I'm sure that they will say again today, that, well, but if we had gone to court, the Trump administration would have said that the courts don't have jurisdiction over those claims. Now that is true. In some cases, there's one being litigated right now related to the former counsel to the president, Don McGahn. The Trump administration position, just like the position of the Obama administration, is that an effort by the House to enforce a subpoena in Article 3 court is a non-justiciable controversy. That is our position, and we would argue that in court. But that's part of what would have to be litigated. That doesn't change the fact that the House managers can't have it both ways. And I want to make this clear. The House managers want to say that they have an avenue for going to court. They're using that avenue for going to court. They actually told the court in McGahn that once they reached an impasse with the executive branch, the courts were the only way to resolve the impasse. And as I explained the other day, there are mechanisms for dealing with these disputes between the executive and Congress. The first is an accommodations process. They didn't do that. We offered to do that in the White House counsel's October 8th letter. They didn't do accommodations. If they think they can sue, they have to take that step because the Constitution, the courts have made clear, require incrementalism in disputes between the executive and the legislative branch. So if they think that the courts can resolve that dispute, that's the next step. They should do that and have that litigated. And then things can proceed on to a higher level of confrontation. But to jump straight to impeachment, to the ultimate constitutional confrontation, doesn't make sense. It's not the system that the Constitution requires, and it is unprecedented in this case. Thank you.
Thank you, counsel. The senator from Michigan.
Thank you, Mr. Chief Justice. I send a question to the desk.
Okay, well, here we go. The senators are asking questions. The Chief Justice is reading the questions, and the counsel for the president and the House managers are responding to the questions from the senators in the Senate impeachment trial of the 45th president of the United
Senator
States.
Stabenow asked the House managers, would the House managers care to correct the record on any falsehoods or mischaracterizations in the White House's opening arguments?
So both sides are just sending up a thing so they can keep doing what they've been doing. You know, I don't know. It seems like if you want to convince 10, 20 senators, which I think would be cool.
Mr. Chief Justice and Senators, thank you for that question. We believe that the president's team has claimed basically there were 6 facts that have not been met and will not change, and all 6 of those so-called facts are incorrect. Let's be clear, on July 25th, that's not the whole evidence before us, even though it includes devastating evidence of the president's scheme. President Trump's intent was made clear on the July 25th call, but we had evidence of information before the meetings with Mr. Bolton, the text message to Mr. Zelensky's people telling him he had to do the investigations to get what he wanted. All of this evidence that makes us understand that phone call even more clearly.
That's
Now,
Zoe Lofgren, California.
the president's team claimed that Mr. Zelensky and other Ukrainians said they never felt pressure to open investigations. Now, of course, they didn't say that publicly. They were afraid of the Russians finding out. But Zelensky said privately that he didn't want to be involved in U.S. domestic politics. He resisted announcing the investigations. He only relented and scheduled the CNN meeting after it became clear that he was not going to receive the support that he needed and that Congress had provided in our appropriations. That's the definition of pressure. Now, Ukraine, the president's lawyers say, didn't know that Trump was withholding the security assistance until it was public. Many witnesses have contested that, including the open statement by Olena Zirkle, who was then the deputy foreign minister of Ukraine, that they knew about the president's hold on the security matters. And in the end, everyone knew it was public. And after it was, Ukraine did relent and schedule that testimony. Fourth, they said no witnesses said security was conditioned on the investigations. Not so. Mulvaney, we had other witnesses talking about the shakedown for the security assistance. But the important thing is that you can get a witness who talked to the president firsthand about what the president thought he was doing. Ultimately, of course, the funds, or at least some of them, were released. But the White House meeting that the president promised 3 different times still has not occurred. So, and we still don't have the investigation of the Bidens. Getting caught doesn't mitigate the wrongdoing. The president's unrepentant, and we fear he will do it again.
Yeah.
Now, the Independent Government Accountability Office concluded that the president violated federal law when he withheld that aid. That misconduct is still going on. All the aid has not yet been released. And finally, I'd just like to say there's been some confusion, I think, I'm sure not intentional, but the president surely does not need the permission of his staff about foreign policy. That information is offered to you as evidence of what he thought he was doing. And he did not appear to be pursuing a policy agenda. He appeared from all the evidence to be pursuing a corruption of our election that's upcoming, a high crime and misdemeanor that requires conviction and removal. I yield back.
Mr. Chief Justice,
The senator from Arkansas.
I send a question to the desk for the President's Counsel on behalf of myself and Senators Bozeman, McSally, Blackburn, Kennedy, and Toomey.
There we go. There's going to be another dumb question from the right wing that supports their defense of a man who has violated his oath, a man who does not have the temperament for the job. All lining up behind him because they're pawns of a larger game.
The senators asked the president's counsel, did the House bother to seek testimony or litigate executive privilege issues during the month during which it held up the impeachment articles before sending them to the Senate?
Mr. Chief Justice, Senators, no, the House did not seek to litigate any of the privilege issues during that time. In fact, they filed no lawsuits arising from this impeachment inquiry to seek to contest the bases that the Trump administration gave for resisting the subpoenas, the basis for why those subpoenas were invalid. And when litigation was filed by one of the subpoena recipients, that was Dr. Charles Kupperman, the Deputy National Security Advisor, he went to the court and sought a declaratory judgment saying, President's told me I shouldn't go. I have a subpoena from the House saying I should go. Please, courts, tell me what are my obligations. And that was filed, I believe, around October 25th. It was towards the end of October. Very shortly, within a few days, the court had set an expedited briefing schedule and scheduled a hearing for December 10th that was supposed to hear both preliminary motions to dismiss, but also the merits issues. So they were going to get a decision after a hearing on December 10th that would go to the merits of the issue. The House managers withdrew the subpoena. The House of Representatives decided they wanted to moot out the case so they wouldn't get a decision. So no, the House has not pursued litigation to get any of these issues resolved. It's affirmatively avoided getting any litigation. And that seems to be, at least in part, based on, if you look at the House Judiciary Committee report, their assertion that under the sole power of impeachment assigned to the House believes that the Constitution assigns, I believe the exact words are, it gives the House the last word, something to that effect. And I mentioned this the other day. This is the new constitutional theory that because they have the sole power of impeachment, in their view, it's actually the paramount power of impeachment. And all other constitutionally based privileges or rights or immunities or roles even of the other branches, both the judiciary and the executive, fall away. And there is nothing that can stand in the way of the House's power of impeachment. If they issue a subpoena, the executive has to respond. And it can't raise any constitutionally based separation of powers concerns. If you do, that's obstruction. The courts have no role. The House has the sole power of impeachment. And that's a very dangerous construct for our Constitution. It suggests that once they flip the switch onto impeachment, there's no check on their power, on what they want to do. And that's not the way the Constitution is structured. The Constitution requires, when there are interbranch conflicts, that there be an accommodation process, that there be attempts to address the interests of both branches. And the House has taken the position, and in other litigation, the McGahn litigation, they're telling the courts are the only way to resolve these issues. And they brought that case in August. They already have a decision from the district court. They have an appeal in the DC Circuit. It was argued on January 3rd. A decision could come any day. That's pretty fast for litigation. But they've decided in this impeachment they don't want to do litigation. And again, it's because they had a timetable. One of the House managers admitted on this floor they had to get the president impeached before the election. They had no time for the courts, for anyone telling them what the rules were. And they had to get it done by Christmas, and that's what they did. And then they waited around for the month before bringing it here. And I think that shows you what's really behind the claims of, oh, it's urgent, then it's not urgent. It's urgent when it's our timetable to get done by Christmas. It's not so urgent when we can wait for a month because we want to tell the Senate how to run things. It's all a political charade. And that's part of the reason, a major reason, that the Senate should reject these articles of impeachment. Thank you.
Thank you, counsel.
Justice,
The senator from New Mexico.
thank you for the recognition, Mr. Chief Justice. I send a question to the desk.
The question is for the House managers. Please address the President's counsel's argument that House managers seek to overturn the results of the 2016 election and that the decision to remove the president should be left to the voters in November.
Good question. See who it'll be. Probably Schiff. Because it's more of a general, larger question.
Thank you for the question.
It is.
And, first I just want to respond to something counsel just said. 9 months is pretty fast for litigation in the courts. Sadly, I agree with that. 9 months is pretty fast in the McGahn case, and we still don't have a decision yet. And what's more, that's the very case in which they're arguing, as I quoted earlier, that Congress has no right to come to the courts to force a witness to testify. So here we are 9 months later in that litigation that they said we're compelled under the Constitution to bring, and they're saying in court, you can't bring this, and it's 9 months and we still don't have a decision. I think that tells you just where they're coming from. It all goes back to the president's directive, fight all subpoenas, and they are. Nixon was going to be impeached for far less obstruction than anything that Donald Trump did. Now, the argument, well, if you impeach a president, you are overturning the results of the last election and you're tearing up the ballots in the next election. Okay, if that were the case, there would be no impeachment clause in the Constitution. Because by definition, if you're impeaching a president, that president is in office, has won an election. Clearly, that's not what the founders had in mind. What they had in mind is if the president commits high crimes and misdemeanors, you must remove him from office. It is not voiding the last election. It is protecting the next election. Indeed, the impeachment power was put in the Constitution not as a punishment. That's what the criminal laws are for, but to protect the country. Now, if you say you can't impeach a president before the next election, what you're really saying is you can only impeach a president in their second term. Okay, if that were going to be the constitutional requirement, the founders would have put in the Constitution, a president may commit whatever high crimes and misdemeanors that he wants as long as it's in the first term. That is clearly not what any rational framer would have written, and indeed they didn't. And they didn't for a reason. The founders were concerned that, in fact, the object of a president's corrupt scheme might be to cheat in the very form of accountability that they had prescribed, the election. So Counsel has continued to mischaracterize what the managers have said. We're not saying that we had to hurry to impeach the president before the election. We had to hurry because the president was trying to cheat in that election. And the position of the president's counsel is, well, yes, it's true that if a president is going to try to cheat an election, by definition, that's prior to their re-election. By definition, that's going to be proximate to an election. But let the voters decide, even though the object is to corrupt that vote of the people. That cannot be what the founders had in mind. One of the things I said at the very open of this proceeding is, yes, we're to look to history. Yes, we're to try to divine the intent of the framers, but we are not to leave our common sense at the door. The issue isn't whether this is his first term or his second. It isn't whether the election is a year away or 3 years away. The issue is, did he commit a high crime and misdemeanor? Is it a high crime and misdemeanor for a president of the United States to withhold hundreds of millions of dollars in aid to an ally at war to get help, illicit foreign interference in our election?
Yes, it is.
If you believe that it is, it doesn't matter what term it is. Doesn't matter how far away the election is, because that president represents a threat to the integrity of our elections, and more than that, a threat to our national security. As we have shown by withholding that aid, and I know the argument, no harm, no foul, we held aid from an ally at war. We sent a message to the Russians when they learned of this hold that we did not have Ukraine's back. We sent a message to the Russians as Zelensky was going into negotiations with Putin to try to end that war, that Zelensky was operating from a position of weakness because there was a division between the president of the United States and Ukraine. That's immediate damage. That's damage done every day. That damage continues to this day. The damage the president does in pushing out the Russian conspiracy theories were identified during the House proceedings, and you've heard in the Senate, as Russian intelligence propaganda. The danger the president poses by taking Vladimir Putin's side over his own intelligence agencies.
That's crazy, dude.
That's
Come on.
a danger today.
Yes, it is.
It's a danger that continues every day he pushes out this Russian propaganda. The framers, if they meant impeachment only to imply in a second term, would have said so, but that would have made the Constitution a suicide pact. That's not what it says, and that's not how you should interpret it.
Thank you. The senator from Ohio.
Yes.
Thank you.
So now this will be a right-wing version of what you just heard. A softball question for them to be able to. At least they're 5 minutes now and not 20 minutes of presentation, right?
The question is directed to counsel for the president. Given that impeachment proceedings are privileged in the Senate and largely prevent other work from taking place while they are ongoing, please address the implications of allowing the House to present an incomplete case to the Senate and request the Senate to seek testimony from additional witnesses.
Who gives a crap? That's just you don't even want to know. That's you saying I don't need to know. I don't want to know. I'd rather go to the toilet.
Thank you, Mr. Chief Justice, senators. I think this is one of the most important issues that this body faces, given these calls to have witnesses, because the House managers try to present it as if it's just a simple question, how can you have a trial without witnesses? But in real litigation, no one goes to trial without doing discovery. No one goes to trial without having heard from the witnesses.
You said you won't stand
first.
for
You don't
subpoenas.
show up at trial and then start trying to call witnesses for the first time. And the implications here in our constitutional structure for trying to run things in such an upside down way would be very grave for this body as an institution. Because as the senator's question points out, it largely prevents this chamber from getting other business done as long as there is a trial pending. And the idea that the House can do an incomplete job in trying to find out what witnesses there are, having them come testify, trying to find out the facts, just rush something through and bring it here as an impeachment, and then start trying to call all the witnesses, means that this body will end up taking over that investigatory task. And all of the regular business of this body will be slowed down, hindered, or prevented while that goes on. And it's not a question of just one witness. It's not a question, a lot of people talk right now about John Bolton, but the president would have the opportunity to call his witnesses just as a matter of fundamental fairness.
Let's do it.
And there would be a long list of witnesses.
Let's go.
If
I'm
the
ready.
body were to go in that direction.
Let's do
It
it.
would mean this would drag on for months.
Fine, no problem
And
with
prevent
me.
this chamber from getting its business
That's
done.
its job, friend.
There's a proper way to do things and an upside down way of doing things. And to have the House not go through a process that is thorough and complete, and to just rush things through in a partisan and political matter and then dump it onto this chamber to clean everything up is a very dangerous precedent
What a
to be
lie.
set. As I said the other day, whatever is accepted in this case becomes the new normal. If this chamber puts its imprimatur on this process, then that's the seal of approval for all time in the future. And if it becomes that easy for the House of Representatives
Imprimatur.
to impeach a president of the United States, don't attempt to subpoena the witnesses, never mind litigation, it takes too long, but then leave it all to this chamber. And as I said the other day, remember, what do we think will happen if some of these witnesses are subpoenaed now that they never bothered to litigate about? Then there'll be the litigation now, most likely. And then that will take time while this chamber is still stuck sitting as a court of impeachment. That's not the way to do things. And it would forever change the relationship between the House of Representatives and the Senate in terms of the way impeachments operate. So I think it's vitally important for this chamber to consider what it really means to start having this chamber do all that investigatory work, how this chamber would be paralyzed by that. And is that really the precedent? Is that the way this chamber wants everything to operate in the future? Once you make it that much easier, and we've said this on a couple of different points, both in terms of the standards for impeachable offenses, but also in terms of the process that's used in the House. You make it really way too easy to impeach a president, then this chamber is going to be dealing with that all the time. And as Minority Leader Schumer had pointed out, at the time of the Clinton impeachment, he was prophetic. As White House counsel pointed out the other day, once you start down the path of partisan impeachments, they'll be coming again and again and again.
Got no problem with that.
And if you make it easier, they'll come even more frequent.
That's great.
And this chamber is going to have to spending a lot of time dealing with impeachment
I
trials.
have no problem with that at
and
all.
cleaning up incomplete, half-baked procedures.
As I've said
partisan
before, why don't
impeachments
we just
from the
impeach
House,
every president
if
until we
that's the
get
sort
one
of
that's
system that's given an
unimpeachable?
imprimatur here. And that's a very important reason for not accepting that procedure and not trying to open things up now when things haven't been done properly in the House of Representatives. Thank you.
So, the senator from Delaware.
Chief Justice, I send a question to the desk.
The question is for the House managers. Some have claimed that subpoenaing witnesses or documents would unnecessarily prolong this trial. Isn't it true that depositions of the 3 witnesses in the Clinton trial were completed in only 1 day each? And isn't it true that the Chief Justice, as presiding officer in this trial, has the authority to resolve any claims of privilege or other witness issues without any delay?
Mr. Chief Justice, the answer is yes. What is clear, based on the record that was compiled by the House of Representatives, where up to 5 depositions per week were completed, that this can be done in an expeditious fashion. It's important to note that the record that exists before you right now contains strong and uncontroverted evidence that President Trump pressured a foreign government to target an American citizen for political and personal gain as part of a scheme to cheat in the 2020 election and solicit foreign interference. That is evidence from witnesses who came forward from the Trump administration, including individuals like Ambassador Bill Taylor, West Point graduate, Vietnam War hero, including individuals like Ambassador Sondland, who gave $1 million to President Trump's inauguration, respected national security professionals like Lieutenant Colonel Alexander Vindman, as well as Dr. Fiona Hill. 17 different witnesses Trump administration employees, troubled by the corrupt conduct that took place as alleged and proven by the House of Representatives. But to the extent that there are ambiguities in your mind, this is a trial. A trial involves witnesses. A trial involves documents. A trial involves evidence. That is not a new phenomenon for this distinguished body. The Senate in its history has had 15 different impeachment trials. In every single trial, there were witnesses. Every single trial. Why should this president be treated differently, held to a lower standard at this moment of presidential accountability? And in fact, in many of those trials, there were witnesses who testified in the Senate who had not testified in the House. That was the case most recently in the Bill Clinton trial. It certainly was the case in the trial of President Johnson. 37 out of the 40 witnesses who testified in the Senate were new. 37 out of 40. Why can't we do it in this instance? When you have such highly relevant witnesses like John Bolton, who had a direct conversation with President Trump, indicating that President Trump was withholding the aid because he wanted the phony investigations. Counsel has said the greatest invention in the history of jurisprudence for ascertaining the truth has been the vehicle of cross-examination. Let's call John Bolton. Let's call Mick Mulvaney. Let's call other witnesses, subject them to cross-examination, and present the truth to the American people.
Mr. Chief Justice.
The senator from Texas.
Mr. Chief Justice, I have to send a question to the desk.
Thank you. Senator Cornyn asks counsel for the president, what are the consequences to the presidency, the president's constitutional role as the head of the executive branch, and the advice the president can expect from his senior advisors if the Senate seeks to resolve claims of executive privilege for subpoenas in this impeachment trial without any determination by an Article III court?
Mr. Chief Justice, thank you, Senator, for the question. The Supreme Court has recognized that the confidentiality of communications with the president is essential. Keeping those communications confidential is essential for the proper functioning of government. In Nixon versus the United States, the court explained that this privilege is grounded in the separation of powers and essential for the functioning of the executive. For this reason, in order to receive candid advice, the president has to be able to be sure that those who are speaking with him have the confidence that what they say is not going to be revealed, that their advice can remain confidential. If it's not confidential, they would temper what they're saying. They wouldn't be candid with the president. And they wouldn't be able, the president then would not be able to get the best advice. And it's the same concern that underpins the deliberative process aspect of executive privilege. Even if it's not a communication directly with the president, if it's the deliberative process within the executive branch, people have to be able, before coming up with a decision, to discuss alternatives, to probe what other ways might work to address a problem, and to discuss them candidly and openly, not with the feeling that the first thing they say is going to be on the front page of the Washington Post the next day. Because if you don't have the confidence that what you're saying is going to be kept confidential, you won't be candid, you won't give your best advice. And that damages decision-making. That's bad for the government and it's bad for the people of the United States because it means the government and the executive branch can't function efficiently. So there is a critical need for the executive to be able to have these privileges and to protect them. And that's why the Supreme Court recognized that in Nixon versus United States and pointed out that there has to be some very high showing of need from another branch of government if there's going to be any breach of that privilege. And that's why there is an accommodations process. While the courts have said that when the Congress, when the legislature seeks information from the executive, and the executive has confidentiality interests, both branches are under an obligation to try to come to some accommodation to address the interests of both branches. But it's not a situation of simply the Congress is supreme and can demand information from the executive and the executive must present everything. And the courts have made that clear because that would be damaging to the functioning of government. And so here in this case, there are vital interests at stake. And, you know, in one of the potential witnesses that the House managers have raised again and again is John Bolton. John Bolton was the national security advisor to the president. He has all of the nation's secrets from the time that he was the national security advisor. And that's precisely the area, the field in which the Supreme Court suggested in Nixon versus United States, there might be something approaching an absolute privilege of confidentiality in communications with the president, the field of national security and foreign affairs. That's the crown jewels of executive privilege. And so to suggest that the national security advisor, well, we'll just subpoena him, he'll come in and that'll be easy, there won't be any problem. That's not the way it would work because there's a vital constitutional privilege at stake there. And it's important for the institution of the office of the presidency, for every president to protect that privilege. Because once precedents start to be set, if one president says, well, I won't insist on the privilege then, I'll let people interview this person, I won't insist on the immunity, that sets precedents. And then the next time, when it's important to preserve the privilege, the precedent is raised and the privilege has been weakened and it's forever weakened. And that damages the functioning of government. So this is a very serious issue to consider. It's important, the Supreme Court has made clear, for the proper functioning of the executive branch, for the proper functioning of our government. And there would be grave issues raised attempting to have a national security advisor to the president come under subpoena to testify. And that would all have to be dealt with. And that would take some time before things would continue. Thank you.
Counsel? The senator from Hawaii.
Mr. Chief Justice, I send a question to the desk.
We are watching the Senate impeachment trial. Senators are questioning both sides, the House managers and the counsel for the president. It is being presided over by the Supreme Court Justice Chief.
The question from Senator Schatz is directed to the House managers. And also from Senator Feinstein.
John Roberts.
If the president were acting in the interest of national security, as he alleges, would there be documentary evidence or testimony to substantiate his claim? If yes, has any evidence like that been presented by the president's counsel?
Thank you, Mr. Chief Justice. Thank you, senators, for the question. The answer is yes. Right? There are well-established processes, mechanisms, and agencies in place
Representative Jason
to pursue valid and legitimate
Democrat, Colorado.
national security interests of the United States, like the National Security Council, like the National Security Advisor, as in Ambassador John Bolton, and many other folks within the State Department and the Department of Defense. And as we have well established over the last week, none of those folks, none of those agencies that would have been involved in having that deliberation, reviewing that evidence, having that discussion, were incorporated into any type of interagency review process during the vast majority of the time that we are talking about here. From the time of the president's call on July 25th to the time the lift the hold was lifted. Those individuals, those agencies were in the dark. They didn't know what was happening. And more so, not only were they in the dark, but the president violated the law by violating the Impoundment Control Act to execute his scheme. None of that suggests a valid, legitimate policy objective. More so, the president himself and his counsel is bringing at issue the question of documents and witnesses. If over and over again, as we've heard in the last few days, that the president was simply pursuing a valid, legitimate policy objective, if this was a specific debate about policy, a debate about corruption, a debate about burden sharing, then let's have the documents that would show that. Let's hear from the witnesses that would show that, because the documents and the witnesses that we have forwarded, that we have talked about, show the exact opposite. So the American people in this chamber deserve to have a fair trial. The president deserves to have a fair trial. In fact, if he is arguing that there is evidence that there was a policy debate, then I think everybody would love to see those documents, would love to see the witnesses, hear from them directly about what exactly was being debated.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from South Carolina.
I send a question to the desk for myself and Senator Cruz.
Thank you.
Oh, so it's guaranteed to be stupid then. Here we go. This is going to be a political question for sure. Denigrating, I bet. It won't be intelligent. At least the previous one was intelligent.
Senator Graham and Senator Cruz pose this question for the House managers. In Mr. Schiff's hypothetical, if President Obama had evidence that Mitt Romney's son was being paid $1 million per year by a corrupt Russian company, and Mitt Romney had acted to benefit that company, would Obama have authority to ask that that potential corruption be investigated?
What?
Well, first of all, the hypothetical is a bit off because it presumes that in that hypothetical that President Obama was acting corruptly, or there was evidence he was acting corruptly with respect to his son. But nonetheless, let's take your hypothetical on its terms. Would it have been impeachable if Barack Obama had tried to get Medvedev to do an investigation of Mitt Romney, whether it was justified or unjustified? The reality is, for a president to withhold military aid from an ally, or in the hypothetical, to withhold it to benefit an adversary, to target their political opponent is wrong and corrupt, period. End of story. And if you allow a president to rationalize that conduct, rationalize jeopardizing the nation's security to benefit himself because he believes that his opponent should be investigated by a foreign power, that is impeachable. Now, if you have a legitimate reason to think that any U.S. person has committed an offense, there are legitimate ways to have an investigation conducted. There are legitimate ways to have the Justice Department conduct an investigation. I would suggest to you that for a president to turn to his Justice Department and say, I want you to investigate my political rival, taints whatever investigation they do. Presidents should not be in the business of asking even their own Justice Department to investigate their rivals. The Justice Department ought to have some independence from the political desires of the president. And one of the deeply troubling circumstances of the current presidency is you do have a president of the United States speaking quite openly, urging his Justice Department to investigate his perceived enemies. That should not take place either. But under no circumstances do you go outside of your own legitimate law enforcement process to ask a foreign power to investigate your rival, whether you think there's cause or you don't think there's cause. And you certainly don't invite that foreign power to try to influence an election to your benefit. It's remarkable to me that we even have to have this conversation. I mean, our own FBI director has made it abundantly clear, and it shouldn't require an FBI director to say this, that if we were approached with an offer of foreign help, we should turn it down. We should, of course, certainly not solicit a foreign country to intervene in our election. And whether we think there's grounds or we don't, the idea that we would hold our own country's security hostage by withholding aid to a nation at war to either damage our ally or help our adversary because they will conduct an investigation into our opponent, I can't imagine any circumstance where that's justified.
Come on, guys.
And I can't imagine
You're
any
not the
circumstance
Republican
where
Party you used to
we would
be.
want to
You're an
say
embarrassment.
the President
The
of the United
Republican Party's
States
an embarrassment.
can target his
Shame on the
rival,
Republican Party.
can solicit,
Sad.
elicit foreign help in an
Disgusting
election,
pawns.
can help him cheat, and that's okay. Because that will dramatically lower the bar for what we have a right to expect in the President of the United States, and that is they're acting in our interests. So I would say it's wrong for President of the United States to be asking for political prosecutions by his own Justice Department. I would say it's wrong for President of the United States to ask a foreign power to engage in investigation of his political rival, but particularly where, as we have shown here, there is no merit to that investigation is even more egregious. And you know there's no merit to it because he didn't even want the investigation. And the more accurate parallel, Senator, would be if Barack Obama said, I don't even need you, Russia, to do the investigation. I just want you to announce it. Because that betrays the fact there was no legitimate basis, because the president didn't even need the investigation done. He just wanted it announced. And there is no legitimate explanation for that except he wanted their help in cheating in the next election.
Thank you, Mr. Manager. The senator from Michigan.
Mr. Chief Justice, I send a question to the desk.
Thank you.
Once again, we are watching the Senate impeachment trial of Donald Trump. Today is the day when the senators get to ask questions of the two sides.
The question from Senator is for the House managers. Does the phrase "or other high crimes and misdemeanors" in Article 2, Section 4 of the Constitution require a violation of the U.S. Criminal Code, or is a breach of public trust sufficient? Please explain.
We already did this, didn't we? It doesn't need to be a crime at all. In fact, it's the opposite. It's a special, unique case of not needing a crime. It's abuse of the power of the office itself. That's the point. The thing that makes me sad is how uneducated these senators are. These
Framers were very clear that abuse of power is an impeachable offense. In explaining why the Constitution must allow impeachment, Edmund Randolph warned that, quote, the executive will have great opportunities of abusing his power. Alexander Hamilton described high crimes and misdemeanors as offenses which proceed from the abuse or violation of some public trust. The framers also described what it meant. It was impeachable for a president to abuse his pardon power to shelter people he was connected with in a suspicious manner. Future Supreme Court Justice James Iredell said the president would be liable to impeachment if he'd acted from some corrupt motive or other, or if he was willfully abusing his trust. As was later stated in a treatise summarizing centuries of common law, abuse of power occurs if a public officer entrusted with definite powers to be exercised for the benefit of the community.
This happens about every 2 hours. The C-SPAN channel requires that you resume the playback. It confirms that you are still in touch with the playback. And that's healthy because it is a nonprofit C-SPAN. And again, please do donate to cspan.org.
C-SPAN, your unfiltered view of government, created by cable in 1979.
A precious.
The founders had been participating with overthrowing the British government, a king who was not accountable. They incorporated the impeachment power into the Constitution, late actually, in the drafting of the Constitution. They knew that they were giving the president many powers, and they specified if he abused them, that those powers could be taken away. Now, the prior articles that the Congress has had on impeachment did not include specific crimes. President Nixon was charged with abusing his power, targeting political opponents, engaging in a cover-up. Now, there was conduct specified. Some of it was clearly criminal, some of it was not, but it was all impeachable because it was corrupt and it was abusing his power. In the House Judiciary Committee, we had witnesses called by both Republicans and Democrats, and the Republican-invited constitutional law expert, Jonathan Turley, testified unequivocally that it is possible to establish a case for impeachment based on a non-criminal allegation of abuse of power. Every presidential impeachment, including this one, has included conduct that violated the law, but each presidential impeachment has included the charges directly under the Constitution. It's important to note that a specific criminal law violation was not in the minds of the founders, and it wouldn't make any sense today. You could have a criminal law violation. You could deface a post office box. That would be a violation of federal law. We would laugh at the idea that that would be a basis for impeachment. That is not abuse of presidential powers. It might be a crime. And yet you could have activities that are so dangerous to our Constitution that are not a crime that would be charged as an impeachable offense because they are an abuse of power. That's what the framers worried about. That's why they put the impeachment clause in the Constitution. And frankly, they opined that because of the impeachment clause, no executive would dare exceed their powers. Regrettably, that prediction did not prove true, which is why we are here today with President Trump having abused his broad powers.
That's right.
To the detriment of our national interest for a corrupt purpose, his own personal interests. Thank you.
Thank you, Counsel.
Mr. Chief Justice.
Oh, Senator, thank you.
Thank you, Mr. Chief Justice. I sent a question to the desk on behalf of myself and Senator Murkowski.
Thank you, Senator.
Once again, we are.
Senators ask Counsel for the President. Describe in further detail your contention that all subpoenas issued prior to the passage of House Resolution 660 are an exercise of invalid subpoena authority by the House committees.
It's a good question.
Mr. Chief Justice, thank you, senators, for that question. As I explained the other day, this contention is based on a principle that has been laid out in several Supreme Court cases, explaining that the Constitution assigns powers to each house of the legislative branch, to the House of Representatives or to the Senate. And in particular, the language of the Constitution is clear in Article 1 that the sole power of impeachment is assigned to the House. That's to the House of Representatives as a body. It's not assigned to any committee, to a subcommittee, or to any particular member of the House. And in cases such as Roomley versus United States and the United States versus Watkins, the court has been called, there are disputes about subpoenas. They're not specifically in the impeachment context, but they establish a general rule, a principle, that whenever a committee of either body of Congress issues a subpoena to someone and that person resists the subpoena, the courts will examine what was the authority of that committee or subcommittee to issue that subpoena. And it has to be traced back to some authorizing rule or resolution from the House of Representatives itself, for example, in a House subcommittee. And the courts will examine, the Supreme Court has made clear that that is the charter of the committee's authority. It gets its authority solely from an action by the House itself. That requires a vote of the House, either to establish the committee by resolution or to establish by rule the standing authority of that committee. And if the committee cannot trace its authority to a rule or a resolution from the House, then its subpoena is invalid. And the Supreme Court's made clear in those cases, such subpoenas are null and void because they're ultra vires. They're beyond the power of the committee to issue. They can't be enforced. And our point here is very simple. There is no standing rule in the House that provides the committees that were issuing subpoenas here under the leadership of Manager Schiff the authority to use the impeachment power to issue subpoenas. Rule 10 of the House defines the legislative jurisdiction of committees. It doesn't mention the word impeachment even once. And so no committee under Rule 10 was given the authority to issue subpoenas for impeachment purposes. And this has always been the case in every presidential impeachment in the history of the nation. There has always been a resolution from the House first to authorize a committee to use the power of impeachment before it attempted to issue compulsory process. So in this case, there was no resolution from the House. The authority, the sole power of impeachment remained with the House of Representatives itself. And Speaker Pelosi by herself did not have authority merely by talking to a group of reporters on September 24th to give the powers of the House to any particular committee to start issuing subpoenas. So the subpoenas that were issued were invalid when they were issued. And then 5 weeks later, on October 31st, when the House finally adopted House Resolution 660 that authorized from that point, purported to authorize at least from that point, the issuance of subpoenas, nothing in that resolution addressed the subpoenas that had already been issued. It didn't even attempt, it didn't purport to say the ones that have already been issued, we're going to try to retroactively give authority for that. It's a separate question whether that could have been done legally. They didn't even attempt to do it. And this is all explained in the opinion from the Office of Legal Counsel, which is in our trial memorandum attached as Appendix C. And it's a very detailed and thorough opinion, 37 pages of legal reasoning, but it explains all of this. The basic principle that applies generally, the history that it has always been done this way. There has always in every presidential impeachment been an authorizing resolution from the House, and the fact that there was none here. So there was no authority for those subpoenas. And that means that 23 subpoenas that were issued were invalid. And this was explained, as I pointed out the other day, in letters from the administration to the committees, a letter from the White House, from OMB, I think the State Department, and in very specific terms, it set out this rationale. So that is the basis on which those subpoenas were invalid and they were properly resisted by the administration. Thank you.
Thank you, counsel. The senator from Pennsylvania.
Mr. Chief Justice, I send a question to the desk.
Thank you.
Once again, we are watching the Senate impeachment trial. Today's senators are asking questions.
The question is directed to the House managers. In Federalist 65, Alexander Hamilton writes that the subjects of impeachment are, quote, those offenses which proceed from the misconduct of public men, or, in other words, from the abuse or violation of some public trust, end quote. Could you speak broadly to the duties of being a public servant and how you believe the president's actions have violated this trust?
Interesting question. Let's see who answers it. Looks like it's going to be possibly Jerry Nadler. We haven't heard from him yet, representative from New York.
Mr. Chief Justice, members of the Senate, President Trump used the powers of his office to solicit a foreign nation to interfere in our elections for his own benefit. Then he actively obstructed Congress in his attempts to investigate his abuses of power. These actions are clearly impeachable. The key purpose of the impeachment clause is to control abuses of power by public officials. That is to say, conduct that violates the public trust. Since the founding of the Republic, all impeachments have been based on accusations of conduct that violates the public trust. When the framers wrote the phrase high crimes and misdemeanors, they intended to capture the conduct of public officials like President Trump, who showed no respect for their oath of office. President Trump ignored the law and the Constitution in order to gain a political favor. The Constitution and his oath of office prohibited him from using his official favor to corruptly benefit himself rather than the American people. That's exactly what the president did, illegally withholding military aid and a White House meeting until the president of Ukraine committed to announcing an investigation of President Trump's opponent. In the words of one constitutional scholar, if what we're talking about is not impeachable, then nothing is impeachable. This is precisely the misconduct that the framers created the Constitution, including impeachment, to protect against. And now I want to add, in reference to some of the comments that were made by some of the president's counsel a few minutes ago. They talk about the subpoena power, about the failure of the House to act properly in the subpoena power, because they said the House did not delegate by rule, have a resolution authorizing the committees to offer subpoena power. They apparently haven't read the fact that the House has generally delegated all subpoena power to the committees. That wasn't true at the time of the Watkins case. It wasn't true 15 years ago, but it is true now. Second, the House has the sole power of impeachment, and the manner of its exercise may not be challenged from outside. Whether we do it, the president should be convicted upon our accusation is a question for the Senate. But how we reached our accusation is a matter solely for the House. Thirdly, they talk about executive privilege, and they point to the Nixon case that established executive privilege, that the president has a right to candid advice, and therefore executive privilege is established. But the same case says that executive privilege cannot be used to hide wrongdoing. And in fact, President Nixon was ordered in that case to turn over all the material. Thirdly, there's the doctrine of waiver. You cannot use executive privilege or any other privilege if you waive it. The moment President Trump said that John Bolton was not telling the truth when he said that the president told him of the improper quid pro quo, he waived any executive privilege that might have existed. He cannot characterize a conversation and put it into the public domain and then claim executive privilege against it. The president, by the way, never claimed executive privilege, ever. He has claimed instead absolute immunity, a ridiculous doctrine that the president has absolute immunity from any questioning by the Congress or by anybody else, a claim rejected by every court that has ever considered it. And finally, the difference from this president and any other president claiming privilege of any sort is that this president told us in advance, I will defy all subpoenas. Whatever their nature, I will make sure that the Congress gets no information. In other words, I am absolute. The Congress cannot question what I do because I will defy all subpoenas. I will make sure they get no information, no matter what their rights, no matter what the situation.
He's guilty.
That is the subject of Article 2 of the
unbelievable.
impeachment because that is a claim of absolute monarchical power.
Thank you, Mr. Manager. The majority leader is
I'm going to
recognized.
suggest after two more questions on each side.
One more. I've been corrected. As I frequently am. One more question on each side. We take a 15-minute break.
Thank you.
Mr. President.
Yes, the senator from Kansas.
I send a question to the desk for the counsel for the president.
Thank you.
So they're going to have just one more question for each side. The previous question was for the House managers, so this one will be for the counsel of the president.
Senator Roberts asks, would you please respond to the arguments or assertions the House managers made in response to the previous questions? Directed to the counsel for the president.
Again, just general, so they can rebut.
Mr. Chief Justice, members of the Senate, I want to respond to a couple. First, with regard to the question or the issues that have been raised as it relates to witnesses. It's important to note that in the Clinton impeachment proceeding, the witnesses that actually gave deposition testimony were witnesses that had either been interviewed by deposition in the House proceedings, grand jury proceedings, and it was specifically, Sid Blumenthal, Vernon Jordan, and Monica Lewinsky. The new witnesses were not being called. That's because the House, in their process, moved forward with a full investigation. That did not happen here. There was another statement that was raised by Mr. Chairman Schiff, Manager Schiff, regarding the Chief Justice could make the determination on executive privilege. And again, with no disrespect to the Chief Justice, the idea that the presiding officer of this proceeding could determine a waiver or the applicability of executive privilege would be quite a step. There's nothing historic precedent. There's no historic precedent that would justify it. But there's something else. If we get to the point of witnesses, then, for instance, if one of the witnesses to be called were by the president's lawyers was Adam Schiff, in the role basically of Ken Starr. Ken Starr presented the report, made the presentation before the House of Representatives, had about 12 hours of questioning, I believe is what Judge Starr had. If Representative Schiff was called as a witness, would in fact then issues of speech and debate clause privilege be litigated and decided by the presiding officer, or would it go to court, or maybe they would waive it? But those would be the kind of issues that would be very, very significant. Senator Graham presented a hypothetical, which Manager Schiff said, well, that's not really the hypothetical, but hypotheticals actually are that. They're hypotheticals. But I'll give you, to use Manager Schiff's words, he talked about it would be wrong if the FBI or the Department of Justice was starting a political investigation of someone's political opponent. And I'm thinking to myself, but isn't that exactly what happened? The Department of Justice and the FBI engaged in an investigation of the candidate for President of the United States when they started their operation called Crossfire Hurricane. He said it would be targeting a rival. Well, that's what that did. He said it would be calling for foreign assistance in that. Well, in the particular facts of Crossfire Hurricane, it has been well established now that in fact, Fusion GPS utilized the services of a former foreign intelligence officer, Christopher Steele, to put together a dossier, and that Christopher Steele relied on his network of resources around the globe, including in Russia and other places, to put together this dossier, which then James Comey said was unverified and salacious, but yet it was the basis upon which the Department of Justice and the FBI obtained FISA warrants, and this was in 2016, against a rival campaign. So we don't have to do hypotheticals. That's precisely the situation. But to take it an additional step, this idea that a witness will be called if this body decides to go to witnesses. that a witness will be called would be a violation of fundamental fairness. Of course, if witnesses are called by the House managers through that motion, well, the President's Counsel would have the opportunity to call witnesses as well, which we would. Thank you, Mr. Chief Justice.
Thank you, counsel. Oh, Senator?
Mr. Chief Justice, I send a question to the
California, of
desk.
course.
Thank you.
This will be the final question, and we'll take a break as well when the Senate takes a break. They're going to take a 15-minute break after this question. Chief Justice John Roberts is reading the questions aloud.
Question from Senator Harris is for the House managers. President Nixon said, quote, "When the president does it, that means that it is not illegal," end quote. Before he was elected, President Trump said, quote, "When you're a star, they let you do it. You can do anything," end quote. After he was elected, President Trump said that Article 2 of the Constitution gives him, quote, "the right to do whatever he wants as president," end quote. These statements suggest that each of them believed that the president is above the law, a belief reflected in the improper actions that both presidents took to effect their reelection campaigns.
Thank you.
If the Senate fails to hold the president accountable for misconduct, how would that undermine the integrity of our system of justice?
It's a good question. And this is the issue before us. Dismissing Donald J. Trump's behavior is not acceptable, folks. We must impeach. He has violated the office.
Mr. Chief Justice, Senators, I think this is exactly the fear. I think if you look at the pattern in this president's conduct and his words, what you see is a president who identifies the state as being himself. When the president talks about people that report his wrongdoing, for example, when he describes a whistleblower as a traitor or a spy, the only way you can conceive of someone who reports wrongdoing as committing a crime against the country is if you believe that you are synonymous with the country, that any report of wrongdoing against the president, the person of the president, is a treasonous act. It is the kind of mentality that says under Article 2, I can do whatever I want, that I'm allowed to fight all subpoenas. Now, counsel has given a variety of explanations for the fighting of all subpoenas. They might have a plausible argument if the administration had given hundreds of documents but reserved some and made a claim of privilege, or the administration has said, we'll allow these witnesses to testify, but with these witnesses, with these particular questions, we want to assert a privilege. But of course, that's not what was done here. What we have instead is a shifting series of rationales and explanations and duplicitous arguments, some made in court and some made here. You have the argument that the subpoenas aren't valid before the House resolution, and then with respect to subpoenas issued after the House resolution, like to Mulvaney, well, those are no good either. You have the argument made that we have absolute immunity, and the court that addresses this says, no, you don't. You're not a king. That argument may be thought of with favor by various presidents over history. It has never been supported by any court in the land. There's no constitutional support for that either. Documents that are being released right now as we sit here, and it's a mystery to the country, and it's a mystery to some of us, how are private litigants able to get documents through the Freedom of Information Act that the administration has withheld from Congress? If they were operating in any good faith, would that be the case? And of course, the answer is no. What we have instead is we're going to claim absolute immunity, even though the court says that doesn't exist. Now, they said, well, the House withdrew the subpoena on Dr. Kupperman. Why would they withdraw the subpoena on Dr. Kupperman when he was only threatening to tie you up endlessly in court? Now, we suggested to counsel for Dr. Kupperman that if they had a good faith concern about testifying, If this was really good faith and it wasn't just a stratagem to delay, if it wasn't just part of the president's wholesale fight all subpoenas, they didn't need to file separate litigation because there was actually a case already in court involving Don McGahn on that
Right.
very subject.
Exactly. It
That
still
was
hasn't been decided.
ripe for decision. Indeed, the decision would come out very shortly thereafter. And we said, let's just agree to be bound by what the McGahn court decides. Well, they didn't want to do that. It became obvious once the McGahn court decision came out because the McGahn court said, there's no absolute immunity. You must testify. And by the way, if you think people involved in national security, i.e. Dr. Kupperman and John Bolton, if you're listening, if you think you're somehow absolutely immune, you're not. So did Dr. Kupperman said, well, now I have the comfort I needed because the court has weighed in. The answer is, of course not. Now, counsel says, well, we might have gotten a quick judgment in Kupperman. Yeah, in the lower court. Do any of you believe for a single minute they wouldn't appeal to the Court of Appeals and to the Supreme Court? And the Supreme Court struck down the absolute immunity argument. They wouldn't be back in the district court saying, okay, he's not absolutely immune anymore, but we're going to claim executive privilege over specific conversations that go to the president's wrongdoing. Okay, that is the sign of a president who believes he is above the law, that Article 2 empowers him to do anything he wants. And I'll say this, if you accept that argument, if you accept the argument that the President of the United States can tell you to pound sand when you try to investigate his wrongdoing, there will be no force behind any Senate subpoena in the future. The fighting all subpoenas started before the impeachment. If you allow a president to obstruct Congress so completely in a way that Nixon could never have contemplated, nor would the Congress of that day have allowed, you will eviscerate your own oversight capability, not
Thank
just
you,
in
counsel.
impeachments.
The majority leader is recognized.
I suggest that we resume at 4 o'clock.
Without objection, so ordered.
He didn't gavel it. Or they didn't mic the gavel, but that's okay. That'll happen sometimes. Okay, so there you have it, folks. We're going to take a break as well, a little 15-minute break, as the impeachment of the 45th President of the United States, Donald J. Trump. The trial continues.
Senate stands in recess until 4 p.m. Eastern Time, the first day of